Right, we're now going to move on. Let's thank our presenters.
Sorry, good.
We're now going to move on to the second topic, which is threats from physician employment and private equity. I'm going to start with the discussion, and then I will be followed by Professor Mark Paul. So let me invite, I'm going to say that there, please. Um, Okay, so we've heard some of these topics already. Physicians can be employed, 80% of physicians are employed directly by hospitals. They can be employed by health maintenance organizations and other kinds of healthcare businesses. They can be employed by them. They can also be employed by physician-owned groups. And you'd think that physician-owned groups and similar models would not interfere with physicians' ability to properly care for their patients. But this can be tricky. This can be a sham, actually. So one way that it can kind of a workaround when you think you have a physician-owned group and it should be focusing on proper care for the patient is when the business that actually owns the group hires a management services organization to manage the practice. And what happens is that this management service organization can install a physician licensed in the state to ostensibly be in charge of the practice, but that physician is a friendly physician to the management service organization. That physician is not there to foster the authority of the physicians or to assure proper patient care. That physician is basically a tool of the management service organization, and they take orders from that MSO and are a figurehead while the MSO calls the shots to benefit the business owner that hired that organization to ostensibly have a physician or physicians running the practice. So that's one of the threats that emerges from a physician employment model. Okay, is you think you're being basically run by a physician, but that physician is actually in the pocket of the business owners. Another threat is making a physician sign a stock transfer restriction agreement when they become employed. So when someone buys your practice, they can sometimes you will in exchange you will get stock in the business that now owns that takes over your practice and now employs you. And so you receive stock in the corporation if it's a corporate owner. But you have to typically sign an agreement when this happens which gives the corporate owner substantial control over what you can do with that stock. So for example, if you were going to try to sell that stock to another physician, you can't do that without the permission of the corporation whose stock you have been given. Okay? And also, even worse, there can be an arrangement where if you displease the corporation whose stock you've been given when your practice is sold to them, they can require you to give it back to them as a punishment for displeasing them. For example, by being, paying in the neck and trying to do what's right for your patients. Another common problem faced by physicians who are employed is they are in the employment agreement. They sign one of the provisions allows them to be terminated without cause. In legalese, they're considered employees at will, and this is not uncommon in employment generally. But the problem in healthcare in particular, or when it's a professional who's being employed, is that a hospital employer or a health insurer can basically terminate you, whether it's terminating your employment or terminating your participation in the insurer's network, so you're no longer participating in the physician, which can be very, very serious, if not fatal, to your practice if that insurer has a very large share of the patient market that you're trying to practice in, and you're no longer now, you're now an out-of-network provider. And it's without cause means that they don't have to give you a reason for why they terminate you, and they don't have to give you a hearing at which you can try to defend yourself against whatever reason, which you haven't been told, and you have no way of protesting or contesting the termination. So, for example, since you're not told why you were terminated, you can't turn, for example, to a court and say that you were terminated in a way that either violates the law or is against public policy. So there, if you advocate for your patients, I mean, there's a case in which a New Hampshire physician was complained that he was part of an HMO, and the medical records that the HMO created had lots of mistakes in them, and those were problematic for patients and other providers who would be taking care of the same patients. And the insurer, which was Health Source New Hampshire, terminated that physician without cause. Said you're out, and there's nothing the physician could do about it. Fortunately, and we'll talk some about this tomorrow, that physician did go to court and said, you have to, judge, you have to declare that this termination without cause provision that I signed cannot be enforced against me. And the New Hampshire court agreed, and there's some court precedent in California that also agreed it. So that could be, but that could be a real problem. Being terminated without cause. And there's nothing you can do, and the reason you were terminated is that you were fighting for what you thought your patient. Another provision that you can typically see in an employment agreement, physician employment agreement, is that any dispute has to be submitted to binding arbitration. Binding arbitration. And arbitration is a method of resolving a legal dispute that doesn't involve going to court, doesn't involve a jury, doesn't involve a hearing or anything like that. It's usually what happens is a complaint is made. So if a physician is upset about some aspect of employment, they can try to get a remedy, but they are forced by this provision in their employment contract to have their dispute heard by an arbitration panel. Typically, for example, it would be a 3-person panel of arbitrators, one of whom would be chosen by the physician, one of whom would be chosen by the employer, and then those 2 arbitrators would pick the 3rd arbitrator. And the idea of that is the 3rd arbitrator would be neutral, right? They wouldn't be on the physician's side or the employer's side. But in fact, and then they would determine whether, in fact, the physician had a valid protest against, for example, being terminated or otherwise punished. And the problem is that it is well known, studies have demonstrated this over and over again, that arbitration has 2 problems. One of which is that arbitrators typically side with corporate defendants against the physicians. There's just a bias there for a variety of reasons, including that arbitrators, even the ones picked by the patient, they want to be able to be picked by the employer in a subsequent arbitration proceeding. They want to have business in the future. The second problem is that arbitration, even if they decide in favor of the physician, will typically not give as much relief. For example, if the physician is asking for monetary compensation for having them forced out of work, typically arbitration will not give them as much compensation as if they went forward with a procedure. Finally, my slides are gone, but finally, we heard about this before from Dr. Barry, non-compete clauses, right? Standard in an employment agreement. If you leave employment, for example, voluntarily, but also if you're terminated without cause, you may not practice within a certain, it's not up on the slide, but you may not practice within a certain distance of where you were being employed for a certain period of time. And some of these non-compete agreements can be draconian. So, for example, there was one where you could not compete within 250 miles for 5 years, which effectively ends your practice, right? The Federal Trade Commission not long ago took aim at non-compete agreements in physician employment agreements and elsewhere, and said that those were illegal and unenforceable. But that is now under litigation. So far as I know, correct me if anybody's heard more recent news, that has not been put into effect. It's under litigation. It's being contested by those who think that they ought to be able to prevent physicians from leaving and setting up competing practices nearby so that they can continue to care for their patients. Any questions about the employment agreement problem? So you were told about, how nice it was to be, sort of looked upon and given attention, paid attention. It's very important if you are going to be in an employment situation, hire a lawyer. You may not have a lot of bargaining power. That's the problem. You may not have the bargaining power to say, well, I will only come to work for you if you don't put in a termination without cause provision. That's tough. So tomorrow we'll talk about other ways that you might get some relief, some protection in that kind of situation. Before I turn it over to Professor Hall, any questions about employment agreements? All right, then. Thank you for joining us, Professor Hall, Professor of Law and Public Health at Wake Forest University School of Law and School of Medicine, who will educate us about private equity ownership of healthcare practices.
Hello, everyone. Can you see and hear me?
Yes.
Okay. For some reason, I can't see myself, but that's what I prefer. Maybe I hit a setting. So I'm going to share my presentation here. What I've decided to do is talk about the corporate practice of medicine. Because it is the legal doctrine that's supposed to prevent all these problems from happening. And it's not doing that very well. And so there's a lot of discussion about reviving this doctrine. So much as Professor Melman did at the beginning, I'm going to sort of give a sense of this area of law from a broad historical perspective, and then sort of bring it up to the modern times and give a little bit of thought about how helpful it might or might not be. So let me just double check again. Are you seeing this okay as far as my AV aspects?
Yes. Yeah.
Great.
Mark, just one quick question.
Yeah.
Are you going to talk about private equity tomorrow morning? Because we have you down talking about corporate medicine tomorrow morning.
Oh, I'm so sorry. I misunderstood. I thought I was only on this panel.
Topics for us, right?
Pardon?
You know, you were going to address both topics for us, yes?
Somehow I did not have that in my head.
Okay. Can you rally and give us a talk tomorrow about corporate practice, do you think? I'm sorry, about private equity?
What time did you have me down for that?
9 o'clock.
I can try to make arrangements for that. Let's confer about that after this. I'm sorry. I just so yes, it's possible. But at the anyway, so I'll go ahead with this for now, right?
Yeah.
Okay. What can I say? I'm getting up in years, and sometimes I don't think I'm confused, but sometimes I miss a beat. So here we go. This oops. Okay. Learning my computer. So we start with the concept that the law prohibits the corporate practice of medicine. It also prohibits the corporate practice of other learned professions, such as law. And what does it mean to, say, engage in the corporate practice? Well, it gets reduced to the idea of doctors can't be employed, but obviously they can be. And so the, a corporation not run by medical professionals that employs medical professionals is sort of at least prima facie engaged in corporate practice. But what do we mean by that? So I like to sort of step it back for a minute and say, follow the money. That what this really gets to the essence of is that if a corporation employs a physician, then those physicians, actions are sort of on behalf of the corporation, and if the corporation then sort of charges for those physician services, it's, the corporation is seen as selling a, a professional service that it's not licensed to sell. Um, and this is why across medicine, we have the distinction between facility services and professional services, that billing is separated between those two in ways that the people in the medical sector are well aware of. But let me just emphasize that that separation is pervasive and unique to North America. By the way, this distinction that grows from our law is sort of amplified throughout, in subtle ways that we've become accustomed to, but is something as simple as uh, why do we sort of nominally refer to both Blue Cross and Blue Shield? Well, historically, it's because Blue Cross first emerged as a hospital insurance, but it only paid for the facility services, facility fees in hospitals, and Blue Shield later came along to insure physician services. And by now they've merged, but it reflects the fact that even now we have separate billing for the one versus the other. That got carried over into Medicare Part A and Part B. Now Part A is free and Part B has a premium. There's a lot of important distinctions, but the idea is that it's a sort of I try to describe to my students almost kind of like some sort of law of nature or something, that's that these two are sort of kept in separate domains, because otherwise you would have to ask, if a corporate entity is charging for professional services, is it compliant or in violation of this corporate practice prohibition? Well, why is corporate practice illegal? Just not why would we choose to prohibit it nominally? I'll point out that, but conceptually, why would we consider it to be illegal? Um, and the simple answer is that the law has always done this for the corporate practice of law. So all the many sort of examples that we see of physicians working for some other entity would just be still, even now, absolutely prohibited in law. You don't see, you can, when you walk into whatever, the Walmart or something, and you can get lots of other sort of services, but you can't get legal services at Walmart. And any sort of attempt to sort of maneuver your way around to that would be quickly shut down. So the idea is, well, if we do this for law, we should also do it for other, important learned professions, such as uh, practicing the healing arts and medicine. So the source for this is seen to be the statute that prohibits the unlicensed practice of medicine. So it's a simple syllogistic reasoning that, you have to have a license to practice medicine, and corporations aren't licensed. But underlying that kind of superficial logic is a very strong public policy concern that, um, uh, you know, physicians or other learned professions being beholden to a corporate entity undermines professionalism in all the many ways that we've begun to discuss in this conference and that concern us. Um, and so this kind of thinking originated back, over a century ago, with a sort of targeting sort of outright quackery. And I like to give the example of this dentist that became infamous at the turn of uh, the previous century, the early 1900s to the late 1800s. Um, he was a real huckster, and so it's the time of sort of traveling medicine shows and what have you. So that the organized medicine had started to get a handle on that in terms of licensure of doctors, but dentistry was a little slower on the uptake, and so this guy um, started doing dentistry door to door after he got out of medical school, and that was and then he grew that into a traveling medical circus or dental circus, I guess you would call it, where he'd go around with, a band and, entertainers and what have you, and set up in some town square and start, inviting people in to have their bad teeth pulled, and would go through all sorts of chicanery, and and would advertise himself as Painless Parker, and so um, the dental, he had his license. We travel around the country, so he's licensed in a number of states, not around the country, but several different states, and he had his license revoked in several of these states, but he kept on going. Um, and so they tried to stop him by saying that it was in violation of inappropriate, unprofessional advertising. So he changed his name legally to Painless so he can continue to make this claim. All right. Well, I could go on about amusing stories about Painless Parker, but it was that kind of thing that the corporate practice notion arose to say, in this sort of entirely different era, that the kind of robber baron, whatever age of corporatization, where we began to have, concern about excessive corporate power and that sort of thing, really took hold and said, we need to stamp this out. And so what took hold was a very strong version of this doctrine that absolutely prohibited any form of corporate entanglement in professional practice, whether it's law or medicine. To the extent that many scholars, including myself, I began working on this, 40 years ago, so a lot has changed since then. Began to feel like this doctrine was overstated, that was overly broad, overly prohibited. It did not sort of get at the core of our concerns, and therefore, well, you see in a minute that there's been pushback. But one problem with it is that the logic doesn't hold. The statutory logic, as I said, is too superficial. You could also say that a corporation needs a driver's license if they hire drivers, you know the driver's license, but the corporation isn't, because the corporation can't pass an eye exam, and therefore if the acts of the license of the driver gets attributed to the corporation's engaged in driving without a license. Well, that's silly. We don't do that. If we attribute the acts of the employee to the corporation, we also attribute their license status. So simply employing somebody with a license isn't sort of logically prohibited by a licensure statute unless you have a public policy reason. But the public policy reason, I think, it does carry some weight. But what I think got instantiated that I and others criticized in earlier decades was that it was instantiated in a way that was overly strict, or at least seen as such, that would sort of prohibit no version of, even though there was really sort of nothing wrong going on. And so I teach a case that involves, South Dakota, again, sort of several generations ago, where a physician-run clinic was serving low-income patients. And on behalf of the county, and back in a time when the counties were seen as having the principal responsibility before Medicaid and all to take care of the poor, and indigent and those in need of care. And so the county here, for whatever reason, just said, we don't want to pay these bills. I don't know why. We don't really have the backstory. There's no accusation that there was poor services or no service. So they hired a lawyer and seized on a technicality that a couple of the owners of this practice weren't physicians. I think, like the longtime secretary held a few chairs or something of that nature, and that the practice was organized not as a partnership, but as a nonprofit corporation. So even though it sort of seemed to be the purest of the pure, and only good things had happened, the court applied this strict prohibition, saying that on these high principles that we don't want any influence that would debase the learned professions that exist in that rest upon a foundation of sturdy, sterling human character, just kind of upholding the sort of the doctor knows best, lawyer knows best sort of model. So we're persuaded that which tends to debase the professions is at war with the public interest, and therefore contrary to public policy. We pause to emphasize the word tend, because as the trial court found, this clinic was innocent of any unethical intention or practice. Um, and that everything that was done was controlled by, licensed professionals. But our concerns with the tendency of the challenge conduct, not actually what happened. And we're convinced that the practice of the learning professions by a profit corporation tends to the commercialization and debasement. And so we're of the opinion that this mode of conducting business is strictly illegal. And so they ruled that as a result, that if the corporation was illegally sort of constituted, then its contracts couldn't be enforced, and therefore the county didn't have to pay its bills. And so this is an example of sort of a perfectly upright deal getting blown up after, for a technicality that, um, causes heartburn to lawyers. So because of the sort of the overreach, I think, of the public policy rationale and the sort of thinness of the logical statutory rationale, there's been public policy pushback in earlier decades. So the first was that enforcement of the corporate practice doctrine was seen as frustrating the emergence of new forms of healthcare delivery that brought in more sort of the benefits that we now sort of recognize in accountable care organizations through integrated delivery and value-based payment systems and things like that, were sort of ardently opposed by organized medicine, in part for, potential violations of corporate practice. And so it was felt necessary for HMOs to exist, that the federal government had to, through this initial endorsement of the HMO concept, to clear the path, they had to preempt state corporate practice medicine laws. And so if you're a federally qualified HMO, you're not subject to these laws. And since then, states themselves have also enacted exemptions in their statutes. But the point being is that absent this exemption, an HMO that, contracted with or employed doctors could easily be found in violation, and some were. Beyond that, the Federal Trade Commission actually went after the American Medical Association in the 70s and said, simply, rigorously enforcing the corporate practice principle violates the antitrust laws. They meant principally we're going after advertising, prohibitions of advertising, but they said any sort of organized medical attempt, any attempt by organized medicine to sort of police the professional um, the business aspects of professional practice is either potentially or actually a violation of the antitrust laws, because the American Medical Association is just a voluntary trade association and therefore sort of constitutes a walking conspiracy. So that too, has attracted a lot of scholarly attention, but it's thought to be um, to mean that the enforcement of these laws has to be left to the courts and things like that. So you have those two examples of sort of the pendulum swinging away from this doctrine toward to the extent that when some scholars assessed this body of law a few years ago with a view towards what's going on with private equity, they said, well, still in, you know, uh, maybe a quarter of states or so that are in the darker color, the doctrine's still enforced with maybe a few narrow exceptions. But in the vast majority of the country, either the doctrine's been forgotten about, or it's riddled with so many exceptions that it's sort of an afterthought. And so that sort of shift in attitude and enforcement activity brought about this opportunity for private equity to step in and begin to essentially buy out physician practices. Now, as Professor Melman said, sometimes they have to do that in these darker colored states in ways that sort of appear to sort of paper over the prohibition that still exists on the books. Well, let me just point out that I'll get to that point in a minute, but with regard to exceptions, private equity isn't the only one. The biggest is hospital employment. And you might pause to ask, well, let me just back up a second. one of the initial exceptions that was enacted besides HMOs, but even before that in the 60s was for um, uh, professional corporations and now professional LLCs. So it required, again, statutory enactment at the state level to say that arrangements like the Bartram County one, which happened in the 30s or 40s, are legal if it's only professionals who own the corporation. And so if it's professionals practicing for sort of tax reasons or whatever reasons as a corporate structure rather than a partnership, that's fine. As long as it's all professionally controlled and owned. Then we move to hospitals. What about, again, they're not professionals, but there was challenges to hospital employment that essentially were rejected in most states. Texas is an example, or California, a couple of the strong ones. You still need workarounds, but in most states, that's permitted simply because under the licensing argument, hospitals have a license to essentially practice medicine in some form. And so employing physicians is seen as consistent with the license the hospitals have. And so you avoid that technical argument. And you could say for public policy reasons, this is permissible. And so that's essentially what emerged in case law in the 80s and later. But as Professor Mellon pointed out, practice management arrangements can also be constructed that avoid this nominal prohibition simply because it's a prohibition of the corporate practice of medicine, not the corporate practice of practice management. So if you take sort of this moneyed interest and move it out to the side, and this is simply a diagram describing what Professor Mellman or depicting what Professor Mellman described, you have this practice entity, which is the light-colored um, triangle that complies because it falls under the professional corporation allowance. And it can then contract with a for-profit management company in exchange for the fee. And the fee can sort of, in many states, be based on not just like a service fee, but a percent of the profits in essence. So you have a sort of a profit sharing arrangement or with this management company in exchange for not medical care, but management services. And the management company does on the billing. So it looks like the management company is engaged in selling professional practices, but no, they're just engaged in a contracted billing service. So they do that billing on behalf of the entity. But by the time you sort of pay the fee based on a percentage of revenues, it's harder to get approved a percentage of the profits, but a percentage of revenues is close enough to they get a stake in the action. And then you add to that this idea of a physician owner who's beholden to that management company, who the management company, picks and has under contract and is subject to all these stock restriction agreements and such. So this is actually talking about private equity, and I think it builds nicely on the groundwork that Professor Mellman laid, which is those sort of bundle of contractual provisions he described are all used in this way to sort of tighten the noose around this happily colored light blue. I guess I could have done a little harder to make this in basketball season, Tar Heel blue versus Duke blue. But in any event, they're kind of neither one close. But you can see the way in which this practice entity is caught in a noose, even though technically on paper, because it's only owned by physicians, it's still exempt for the doctrine, and because it's only contracting for management services, it hasn't crossed the line. But in essence, it has. So this is what I think should happen, and this is sort of where I've come around to saying I'm now much less of a critic of this doctrine because I do think it gives the kind of muscle needed to try to, if not halt or reverse, at least put some guardrails on these very worrisome corporatization practices. And so in doing so, and this is, I think, a conversation that many states have begun to engage in through their medical societies, still facing the problem that medical societies might get slapped down on antitrust grounds if they push too hard. But at least thought leaders beginning to explore these is maybe a revival of the doctrine that's more moderated and less absolutist and less sort of strictly prophylactically prohibitive, but focusing on particular arrangements that pose greater risk, rather than say no form of corporatization is permitted, because that's unrealistic in the modern, given the tides of time that Professor Melman's described, and that look not just to clinical autonomy, saying, well, the doctors are still making the clinical decision, which, but the financial autonomy, to say that if they aren't really running their business, that's what, we're concerned about. And so we can begin to think about ways of assessing that directly, and saying, when we see that, that's when we want to step in and say you've crossed the line. And so beginning to articulate some sort of concept, both of acceptable clinical, medical prerogative, but also operational control. When staffing and things like that really kind of get to the essence of being able to practice medicine in the appropriate environment. And to do that, I would certainly be open to some type of antitrust safe harbor, or ruling that at least allows some leadership, some thought leadership in this area, rather than going back to the time when you could have your license taken away for engaging in, painless Parker type of practices. um, you know, Permit the authorities at least to, articulate best practices in ways that are sort of non-threatening or non-punitive, but, ideal setting that this is, and this could be done, I think, either in ways of, warning flags to physicians. If, these sort of bundle of provisions that Professor Melman outlined are there, you should ask yourself, serious questions about, or model contract provisions for things like that, that I think now would be kind of dangerous under antitrust law, but we need, I think, a better sort of more vocal voice for what are inappropriate constraints on professionalism and what are sort of model settings. And so that brings me to the end of my advanced, advanced look presentation, which I will not repeat tomorrow, but it combines my thoughts about corporate practice and how it applies to private equity. So happy to take questions and engage in discussion.
Thank you, Professor Hall. Anybody have a question? So I have a question, and that is, one of the things we talked about in a class that I held, that we talked about this is, so if we were to revitalize, and this is again kind of what we were hoping to talk about tomorrow, but that's okay. If we were going to revitalize the corporate practice of medicine doctrine in, to target specific objectionable practices, do you see that having a retroactive application? And if not, how is it going to really help that much? You see what I'm saying? How would that work in practice? I'm just wondering. Everybody understand what I'm saying? I mean, you have an existing arrangement, and now it's determined to be, objectionable because it takes away too much discretion, clinical discretion from the physicians. How do we, how is that as a practical matter going to work if we adopt that kind of restriction?
Well, that's an important question, and one of the sort of practical rubber hits the road sort of problems that would have to be solved. And there's an argument that's, I think, significant, that investors had sort of an expectation that what they were putting money into would be permitted, and if they're suddenly told it's not permitted and they have to sell out in some kind of fire sale or whatever, they could say, well, our sort of legitimate investment expectations were defeated. Now that wouldn't sort of be unconstitutional, but I think their investors include, powerful people, university endowments and such invest in private equity and all sorts of others, and union trust funds and things like that. So, that would require some thought, and I'm going to just fire off the top of my head here. One point is to note that same argument was made when Congress enacted the No Surprises Act, because it was targeted at a form of private equity that really sort of took advantage of the opportunity to demand exorbitant prices for physicians who could remained out of network and still had to out of managed care networks and still had to be paid because they were central, like emergency medicine and anesthesiology. So you had this sort of onrush of private equity. It's an example of sort of how this investment form kind of sniffs out these more vulnerable, ripe for exploitation situations that come in and say, well, why do you accept, 200% of Medicare rates? You could demand 500% because who's going to say no to the emergency docs or the anesthesiologists? And it turns out they were right. Well, this argument that, gosh, we bet on sort of being able to, you know, exploit prices and vulnerable consumers didn't carry a lot of public policy weight. So that's an example where that law was put into effect, and it didn't prohibit this form of investment, but it prohibited the business practices that they had invested in. So that, I think, would say, well, if it's shown to be bad enough, I think the idea is you just have to put a stop to it. For lesser sort of less obvious examples, you might need to think about phasing something in. I suppose some grandfathering or but I would think a 10-year sort of phase out or something. I don't know. It would take more creative thought. But there's a quick, long-winded but quick reaction to a good question.
Question? Oh, hang on, we have a question from the audience.
So you mentioned toward the beginning the idea of like for-profit corporations. A lot of the larger health systems aren't like this not-for-profit. I'd be curious if you could comment on that and maybe how that plays a role or doesn't.
Yes, good question. And this is where things get tricky for both lawyers and law professors. In theory, this prohibition applies regardless of profit status based on the statutory argument. Based on the public policy argument, you can argue, well, the nonprofits aren't profiteering, but, of course, we know enough about, how nonprofit hospitals behave and such that we think, well, that's, and antitrust law doesn't regard them as being any less sort of avaricious or what have you. It doesn't give you permission to have a monopoly. So you kind of have a mixed, and I think these judges think to themselves, if we allow this for, medicine, then, would we be subject to this? And so some states do recognize an exception for nonprofit organizational forms, and some states don't. So you have a combination. So it does tend to be nonprofit hospitals that is the big exception, and some states would say, well, it applies to hospitals in this case because they happen to be nonprofit, and another state might say, well, it applies to hospitals because they're always licensed. So it produced two different legal landscapes, and the lawyers would have to figure it out. But it's an argument that's given credence, but it's not a sort of a slam dunk argument.
Are there questions from the remote audience? Any other questions from the audience here? All right, if not, we have a break till 3:45. There's snacks that should be out there for you, and we'll reconvene at 3:45 to talk about threats from insurers and private authorization. We'll get private authorization and get more in depth into that. So please come back in an hour and join us again.